located. We are delighted to welcome you to today's webinar on bidder collusion. My name is Jessica Tillotman. I am the Assistant Dean for Government Procurement Law Studies here at the George Washington University Law School. As my colleague Chris Eucken said, this is I believe the 572nd in a series of programs co-hosted by the GW Law Government Procurement Law Program and King's College London, or what I often affectionately refer to as the Chris and Michael Show. The Michael part of this is my wonderful co-moderator for today's panel, Michael Bauscher of King's College London and Moncton Chambers. And also the Chris part of the Chris and Michael Show is my colleague who you've just heard speaking, Christopher Eucken, a professor at GW Law and part of the GW Law Government Procurement Law Program. Before I kick it over to my co-moderator, I just want to say again, thank you. We have had tremendous response to today's webinar. Clearly, there is a growing interest in this subject, whether it is the launch of the United States Procurement Collusion Strike Force, recent developments in the United Kingdom post-Brexit in how it's combating collusion and bid rigging in procurement in the United Kingdom, or even recent guidance issued by the European Commission on how to combat corruption and collusion in government procurement. Clearly, this is an area of interest. It's a growing compliance concern for companies. It's a growing enforcement concern of global enforcement authorities. And of course, from an academic perspective, we're just delighted to see all of these recent developments, and we're here to help hopefully decode them a bit, discuss it from an overview of what each country or what each geographic area is doing, help to understand some of the compliance challenges, and learn a little bit more about what companies, particularly those doing business in multiple jurisdictions, should be aware of as they move forward. So with that, I will turn it over to my co-moderator, Michael Bauscher.
Thank you very much indeed, Jessica, and thank you for your kind introduction, and to Chris for putting, as always, these programs together, and thanks to GW for all the cooperation we've had with King's. I hope that we can. It is true to say that Chris and I have done quite a lot of work in putting some of these programs together, but I'm confident that in due course we can make this a deeper, more institutional link than just the merely personal, but the merely personal is pleasurable as well. Anyway, without more ado, this has been this is a hugely important topic, the interface between public procurement and competition, particularly where bid rigging intrudes into public procurement. It's at the front of the agenda in the three jurisdictions, or three groups of jurisdictions we have with us today: the United States, European Union, and the United Kingdom. And we've got a pair of really star-studded panel of speakers with a pair from each of the three jurisdictions, which we're very privileged to have them all here today. I couldn't possibly do justice to their lists of achievements without taking up a great deal of the time we should be dealing with the substance of the matter. So what I propose to do is refer you for all of the detail to the Public Procurement International website, where Chris has given you links to, or if you just click on each speaker's name, you'll be taken straight through a detailed summary of their achievements. But I'm just going to briefly introduce each of them with one or two key highlights. Our first speaker will be Dan Glad, who is the director of the Procurement Collusion Strike Force at the US Department of Justice. After 7 years in private practice, he was based in Chicago for a long time, first as Assistant Inspector General at the city, dealing with corruption and similar cases, and then as Special Assistant US Attorney, dealing with complex fraud cases and the like. So plainly someone with a lot of deep background and experience in the sorts of issues we're dealing with today. Professor Bill Kovacic, there's no way of doing justice to Bill's achievements, but He is now Professor of Law and Policy at GW, but he's been Chair of the Federal Trade Commission after being a member for many years. He is Non-Executive Director of the UK Competition and Markets Authority. He was Vice Chair for Outreach at the International Competition Network. And I hope that someday we'll return to the old times when he can be the roommate at King's of our colleague, Professor Alison Jones. But it would be a happy day if we could bring that back as well. He'll be speaking on US cartel policy in an international context. Wojciech Hartung, who is in private practice in Warsaw, is co-author of a recent book, Combating Collusion in Public Procurement. And like all good book plugs, I'm going to show you that I've got a copy of the book and I've read it. He was director of the EU and International Cooperation Department in the Public Procurement Office for Poland, and he was the Polish representative on various EU council committees and advisory committees. And he'll be talking about the recent anti-cartel, the recent EU initiative in the field of promoting anti-cartel activity in the public procurement context. And then he'll be followed by Professor Albert Sanchez-Grails to talk about the EU issues. Albert is Professor of Economic Law and co-director of the Centre for Global Law and Innovation at the University of Bristol Law School. He's written extensively on public procurement and competition, and his book, Public Procurement in the EU Competition Rules, is in its second edition, and I forgot to bring my copy off the shelf to show that, but I've got it, it's a promise. Albert was for some time a member of the EU Commission's stakeholder expert group. He blogs extensively. He's the go-to place to find out what is happening in public procurement and competition. He blogged on the EU's initiative within a week of it being published. He had a lot of interesting insights and comments on it then, and we'll be looking forward to see how his thinking has developed since then. Then, as it were, coming home, we turn to the United Kingdom. Juliet Enser is the recently appointed Senior Director of Cartels. It's always a title that slightly worries me. It sounds as if you've gone rogue and gone the wrong side of the fence. But anyway, that's what they call it. That's what you're called. At the Competition and Markets Authority, Juliet has had various roles at the CMA and at its predecessor, the Office of Fair Trading, over the last decade, having previously been in private practice. She will introduce the UK perspective, and I'll come on and mention that briefly. The UK perspective is a little odd, but it is. We will be talking about the Brexit opportunities, and I think it was by chance, my colleague, Professor Alison Jones, will be commenting on exactly that. And by good chance, she had published only a few days before the EU's initiative an article in the Modern Law Review entitled Combating Corruption and Collusion in UK Public Procurement, Proposal for Post-Brexit Reform. And you can find a link to that article on Chris's website. I highly recommend that article, and I'm sure she will give us at least a few tidbits from that article. She's also co-author of one of the leading texts on EU competition law. She's director of the LLB course with European Legal Studies, and most important for my future at King's College London, she's Vice Dean of Academic Staffing. So that's the team, and then shall I, we're perhaps in 1 minute, try and just look at the panorama. This is obviously wildly oversimplified, but I'm going to look at the traffic at the red, orange, and yellow first. The intent here was simply just to show that there is at least some structural similarity between the way in which the US, EU, and UK have dealt with the policing of per se agreements, potentially unlawful agreements, and the public procurement rules under which vendors may be excluded, and I emphasize may be excluded, for being involved in anti-competitive agreements. Once we unpack it, we'll probably see that there are differences as well. Let me just highlight the one particular area on the far right column, and that is the UK's position. The Competition Act is at the moment really derived from EU law, although we'll have to see how that develops. Likewise, the Public Contracts Regulations 2015 are also a rather poorly written transposition of the EU directive, which is in the middle column. It is important to note, and Juliet will come back to it, that we are in the middle of a review of the public contracts regulations. Some of you may have been able to join us a month or so ago where we had an entire seminar about that process. And one of the points which Juliet will pick up is that one of the rather crashing silences in that review program was any reference to bid rigging and public procurement. Fortunately, the CMA, perhaps that means Juliet, did put in a detailed response on this point, and we'll no doubt hear more about that. So we'll be covering the top three. Jessica, did you want to say something about the green row?
Green, AKA how to avoid going to jail. So the green row is really basically compliance. And from a compliance perspective, I think it's one key thing to highlight, and it's that companies need to be aware of this as a risk. Now, that sounds obvious from the outset, but there's a tendency sometimes from companies to basically download whatever seems to be the newest compliance guidance. For example, as cited here, the Department of Justice has released fairly extensive compliance guidance. We know there's compliance guidance from the UK Bribery Act regarding adequate procedures, and think that that's enough, or to look at a competitor's compliance program that might be online and say that that's fine. The key here to me is a company's risk assessment. What is their risk related to issues of collusion or other cartel related behavior? That your compliance program needs to take that into account. It cannot just be some generalizations. Truly, companies need to take that step of conducting a thorough risk assessment to make sure, are they engaging in teaming agreements? Are they engaging in other sorts of behaviors that really are at the margins, difficult legal questions as to whether or not they violate the law? So from a compliance perspective, that's really what companies need to do, is to take that step and determine where their risks are, and frankly, keep apprised of what the standards are. There's some differences, obviously, between the law as outlined here, and I think that will become clear as the governments and develop these laws and begin doing increasing enforcement activity. But from the margins right now, taking into account the most current guidance and incorporating into the compliance programs is key.
Thank you, Jessica. Let me just pick up the grey row, which might seem to be slightly different. This is picking up an issue which is a little odd. In the EU, there has been for some time an initiative towards developing legislation that would help purchasing authorities protect markets from foreign competition where that foreign competition was thought to either benefit from foreign subsidies, or where there was thought to be uneven or unequal access to public markets. Now, those measures had been kept off the statute book by an alliance of member states, probably led, at least partly led, by the UK. So perhaps partly as a result of Brexit, but partly I think also as a change in mood within the EU, that legislation, after a sort of 10 years or so, sort of in the waiting room, seems likely to be about to hit the statute book. And it does raise interesting questions about what the EU really wants out of competition in public sector markets. And that is a topic which Albert, if we get time, we'll come back to comment on. There's a great deal more we could talk about even on this table about the oddities, but let's not waste any more time. Let's move straight on to our first speaker, and who is, I hope, Dan Glad. I hope that's going to be the next slide. Indeed it is. Well, that tells me that that's Dan. Over to you, Dan.
Thank you, and good day. Thank you, Michael, for the kind words of introduction, and thank you to Dean Tiltman and Professor Eukins for the invitation to speak with you and engage in this conversation today. I'm very happy to be here. So let's start. Let's start with some level setting. The fundamental premise, one of the fundamental premises, the benefits of competition. Sellers cut prices. When competition exists, sellers make higher quality products, offer higher quality services, or they innovate. Collusion robs consumers of those benefits of competition. As a result, victims, the consumers, are overcharged and defrauded. Competition suffers, innovation is stifled. And when we're talking about procurement, public procurement, collusion by those in that space causes a direct loss to agencies. And that is a loss that is borne by taxpayers. By one estimate from the OECD, if bid rigging and other collusive conduct were eliminated, governments could save 20% of the costs associated with their procurement. And I'll note that that number can be higher in individual locales. I saw a very recent OECD study in a South American country showing that the number was closer to 25% if collusion and bid rigging were eliminated. And because of those harms, enforcers strive to combat collusion. We look to move the levers where we can, and levers do exist because at root, collusive conspiracies, these are not crimes of passion, done with hot blood, as they say in law school. The decision to collude with competitors is one made by rational actors in the market, rational actors who are seeking to eke out an advantage to which they're not entitled. And as rational actors, these potential colluders in the market make calculations. They weigh risk and benefit. They think about the likelihood of being caught and the certainty of punishment versus the reward from entering the conspiracy. Thus, in the US view, deterrence is possible if enforcers can work those levers, change the incentives to change that calculus, which leads into, it's a nice seg, to the US legal framework and how we approach this conduct here. Next slide, please. Our animating statute in the United States is the Sherman Act, the text of which appears on your screen. The Sherman Act is a classic law from 1890, and it's a conspiracy statute which, under US law, makes certain kinds of agreements crimes. You see them on the screen: price fixing, bid rigging, and allocation, whether that's market or customers. But collusion in the procurement space quite often is more than just those three classic agreements, the per se agreements, the red band from that first slide. We see, and in the United States, we prosecute a variety of offenses that are found in collusive schemes, whether that's various kinds of fraud, bribery and kickbacks, theft from federally funded programs, or money laundering. And we use all those statutory tools to charge individuals who in the United States face incarceration and companies which face criminal fines. And individual accountability is a large part of how the US has historically and to this day seeks to change the incentive structure for rational actors to move those levers. And our traditional ratio, or at least within the past decade and change, is approximately 3 to 1 of individuals to companies charged in our investigation. And there are other consequences, which can include debarment or the interim measure of suspension and civil damages, as well as restitution to victims, making those victims whole. That's also a feature of the US system. And another powerful tool we have as anti-collusion enforcers are our partnerships, which we've strengthened with the Procurement Collusion Strike Force. Next slide, please. The overall concept of the PCSF is that this is a strategic partnership with prosecutors and agents, so the men and women who have badges and firearms who conduct investigations. We are looking to leverage the combined expertise and capacity to better deter, detect, investigate, and prosecute antitrust crimes and related criminal schemes that affect government procurement. And our charge within the PCSF is collusion at all levels of government, federal, state, and local. And our goals are twofold. The first is deterrence and prevention on the front end. Deterrence and prevention through outreach and through training. We do this on the buy side, and this is a really important concept, the buy side, the actual government agencies, the procurement officers, the contract managers who are seeing, who are really, we would say, the tips of the spear, the front line. They're the ones who can see this conduct, who can spot the patterns. And we're training them on identifying the red flags of anti-competitive collusion. Because without education and awareness in that tranche, the enforcers, people like me, will never have the cases. We will not be effectively combating this conduct. We also do sell-side outreach to government contractors, their trade associations, so that they are aware of the red flags, that they can take advantage of the compliance policies which Dean Tillman sort of touched on, and the availability of leniency in the U.S. program. The second objective is to facilitate more effective detection, investigation, and prosecution. And when this conduct is identified, whether by red flags or a tipster, the PCSF has put together a series of teams and squads to jointly investigate and, where appropriate, charge and prosecute these cases. And this strike force has enhanced our detection capabilities. We have we have more than 24, closer to 30 open grand jury investigations since the strike force was set out in November of 2019. Next slide, please. On the screen, you'll see sort of what our setup is, and it's a relationship-focused initiative with teams in 22 different judicial districts in the United States and 7 national law enforcement partners. We're using a district-based model. It's a decentralized task organization, and that's because we recognize one size doesn't fit all, and it empowers our districts to create working partnerships with agencies, federal, state, or local, in their district to create tailored outreach and then respond nimbly to tips and leads when they come in. Next slide, please. And now, implementation and projects. Here are some of the things we're working on. This is a multi-front battle. We are doing many things at the same time. We're engaged in national and localized training, drawing on the expertise of the members of the strike force, whether that's federal offices of inspectors general, which have subject matter expertise into the operations of their respective departments, assistant United States attorneys, who are the line prosecutors in the judicial districts, who have expertise about the players, the industries, and the spending in a district. Antitrust division prosecutors who work these cases day in and day out. The FBI, the Federal Bureau of Investigation, which has broad experience in advanced law enforcement methods. And critically, I'll return to this, data scientists. This model allows us to focus on the buy side and sell side in a variety of locales and a variety of ways, including large public works projects. In my hometown, Chicago, from where I'm speaking, O'Hare International Airport is a large public work project. It has been for several decades. When one project finishes, another one begins. That's a target for effective outreach and training. We also are looking at the largest government contractors or the largest contracts in a particular area and sort of surveying the landscape. The strike force has also been involved in the pandemic response, because we know through history, through our experience, that tumult, disruption, responses to an event like COVID-19 means increased spending, as it must to meet the call of the emergency. But it also has always meant lowered guardrails. My boss once put it, and I love this turn of phrase, it's an enticing opportunity for greed to prevail over ethical conduct, and it exactly is. And we've gone to where the need is greatest, including training customized to the contract management staff who are responding in real time and have been since February or March of 2020. We're talking about the CARES Act, which is a major funding act in the United States, and it allowed for a lot of spending. So we've gone to the Centers for Disease Control and Prevention, the United States Federal Emergency Management Agency, and the United States Army Corps of Engineers, which, despite its name, was a critical part of building and staffing the field hospitals in the early days of the pandemic. We're also engaged in data analytics, leveraging the data tools that all of these agencies have as they take in bids or tenders, realizing that data is an asset and using it as an asset, and developing systems, working with partners, agencies to develop systems to identify red flags in a proactive way. And the final thing we're working on that I want to talk about this morning is PCSF Global. This is a newer project. It's informed in many ways by the Korea Fuels matter, which is really kind of the big bang moment for the strike force and was its animating spark. This is a new international initiative, the PCSF Global. We're partnering with law enforcement officers from United States government agencies who are located overseas to provide training and outreach, to look at the particular risks at all of the U.S. spending in various locales. And it's also building on the Antitrust Division's very successful and long-running leniency program and our recent successes with extradition of foreign nationals to the United States to face justice. In closing, I'll say our use of all available tools, whether it's statutes, resources, or relationships, is a large part of how we're attacking this problem in the United States. And it's working so far for us And I'm really looking forward to the rest of today's panel to see what's working in other jurisdictions. So with that, I'll thank you for your time and your attention. I look forward to the discussion and the Q&A later this morning. Thank you.
Thank you very much indeed. So without more ado, Bill, would you like to, as it says here, comment? Do what it says on the slide.
Michael, I'm most grateful to you, to Jessica, and to Chris for the opportunity of participating in this wonderful program. I'd like to do two things in my comments. One is to underscore the importance of the program that Dan has laid out, and then to suggest some future points of emphasis within the framework Dan has mentioned and some possible elaborations. First, I think it's important to recognize the value of the strategy and tactics that Dan has laid out for us here. The overall recognition that procurement is a special measure, I think, in the eyes of citizens, of the effectiveness of public administration. We are presently spending, and we're on the verge of spending many more trillions of dollars globally in recovery-based efforts. And citizens touch the procurement system all the time, whether it's the sense of how well their schools are working, how good their roads are, how good public transport is, how good public health care is. And even small improvements in the operation of the procurement system not only deliver tremendous efficiency benefits, not only improve wealth distribution and assist the bottom half of the demographic distribution, but also create what my colleague Allison Jones and Rob Anderson from Nottingham have called civic trust, a sense on the part of the larger public at a time of so much fragmentation and discontent that public institutions work for their benefit. So the emphasis that Dan and his colleagues have brought to this topic could not be more important simply in the narrow sense of public procurement or competition law, but I think more broadly for the delivery of good results for each of our nations and to underscore the successful commitment of public institutions to serve their citizens well. The priority Dan describes for this could not be better deserved. What's very promising to me about the DOJ program is that it recognizes certain vital ingredients of an effective strategy going ahead. First, the importance of deeper public agency cooperation. In my time as a public official with one of the US antitrust agencies, it was a standard element of my speeches to talk about the wonderful cooperative relationships we had with everybody. But building those relationships within government is not automatic. As we all know, public procurement authorities do not offer roses and welcomes to competition agencies when they show up for the first time. These relationships are a slow growth, if only because other public institutions are engaged in so many demanding activities that they don't automatically welcome the arrival of someone else who's going to tell them how to do their job better. So the approach that Dan's described requires sustained long-term building of institutional relationships and personal connections. And the renewed commitment of the department to do that, I think, is an indication of what nations generally will have to do if they want to achieve good results. The emphasis on deeper international cooperation. A key example is the commitment of the United Kingdom, the United States, Canada, Australia, and New Zealand to engage in a deeper degree of cooperation under what's called the MMAC framework to realize benefits that can be achieved among competition agencies with similar interests, traditions, and in some ways, public policy programs. This provides a new platform to realize that individual countries working in isolation will be far less effective in achieving good results than they are if they join efforts, pool knowledge, and develop common programs based around the common cause that they have in this area. An extremely important observation that Dan mentions is the importance of analytics. There is, in the field of public administration, what might be called big procurement and big competition policy data. And public agencies will not be successful if they do not emulate the approach of private sector enterprises that have gained tremendous advantage by using artificial intelligence, examining this data, and assembling it into a framework that enables them to do their jobs better than they do now. Dan gave you a glimpse of some of the efforts that the Department of Justice has been using. Juliet Ensor will tell you more about the extraordinary work that's taking place in the Competition and Markets Authority to do this. But the Procurement and Competition Authority of the future will be disarmed if they do not have this capability. They'll be riding a bicycle while a Formula One racer goes ahead of them. And the commitment to analytics, not again just as a talking point, but as a deeply embedded element of policymaking, is so important. I think in the United States, my great hope is that we realize that these initiatives, which have been building over recent years, and they build on other initiatives, ought not be discarded because we've had a regime change. In the United States, we don't do so well in taking what's good and holding on to it as we change administrations. And my dear hope is that we overcome our tendency to say it was all wrong before, and now it will be all better now that we have new management. This is a program that must be sustained over the long term to realize the fullest expression of its potential. To turn last to some comments about what we might do next, and that's on our next and final slide for this segment, to simply turn to some focal points for refinement. First is to echo a comment I just made, and that is to fully embrace what we've learned from COVID. A silver lining from COVID for public administration is that agencies came to understand the desperate necessity of working more closely with their counterparts across government, and that they would not be able to fulfill their obligations effectively if they didn't do this. And indeed, to make data analytics a mechanism for dealing with the downpour of demands that take place during a crisis. And I think a benefit that can come out of this is the full realization that this makes policymaking more effective. It's not a nice to have item, it's a must have item for effective public administration. Second is the multidisciplinary focus that Dan has referred to, and to embed that more deeply in policymaking. There is the famous intersection of policy here that involves not simply procurement, not simply competition, not simply anti-corruption, but also trade. And one thing as policymakers we can do is make elected officials aware, for example, that if you impose severe domestic content requirements and restrict the participation of foreign vendors, you've done cartels a great favor in some ways. Now, there might be good reasons for restricting access, but if I'm a cartel manager, I will praise you if you can deflect entrants from coming in and participating in markets where prices have been going up. So to recognize the collective impact of these policies and their interrelationship is an important step going ahead. The third item is a deeper awareness of our experience in this area, is that you can look at the relationship between cartels and government prosecutors as being an arms race. And cartelists, because of the great value of cartels to cartel members that Dan just described, do not give up. They have never surrendered. And with each advance in detection, prosecution, we have seen creative efforts to adapt and to adjust in order to carry out the variants of the program in question. In short, this contest never ends, and to take into account as policy develops the likely evolution and adaptation. Finally, I think it would be very valuable in looking at individual episodes of collusion involving public procurement to force the cartel members, as a condition of mitigation of punishment, and perhaps for leniency, to require them to engage in an ex post reconstruction of how it happened. Dan underscored a crucial point, I think, that it is not, in the typical case, the rogue employee who runs off and puts together a cartel and keeps it running for 5, 10, 15 years. This is a business model with decisions taken at the highest level of business enterprise. And just as we would examine in a transportation accident why it happened, we should devote perhaps more time to looking at how it happened. Who decided to collude? What techniques did they use to succeed? What surrounding circumstances facilitated success? And what measures will enhance compliance? A good compliance program would consist of efforts to do this internal diagnosis, and I think quite importantly, share this information with public institutions. And who can assess in this reconstruction program and in this process of building effective links? This is where a partnership between the academy, between places like Bristol, King's, GW, Nottingham, can give the public authorities partners who can assist in collecting, analyzing, reviewing data, doing case studies that assimilate, collect, analyze, and apply the lessons of data regarding what's taking place. That's simply within individual jurisdictions, but across them as well. So thanks to Dan and his colleagues for building a good framework for making the investment in the public policy road over which good policy will travel, and for showing us the way to think about this program more effectively in the future. Thanks, Michael.
Michael, you're on mute.
Am I still on mute? Am I still on mute? No? Is my man not working? Can you hear me?
We can hear you. You're just quiet.
Oh, I'm quiet. So that's why I did something stupid. Sorry, apologies. Yes, thank you, Bill and Dan, to explain what we should aspire to do on this side of the Atlantic, and setting out a model which is a long way ahead of what we've achieved in either the EU or the UK. Without more ado, Wojciech, please tell us where are we in the EU and where might we go next?
Thank you very much. First of all, thank you for the invitation. It's a great pleasure for me to be here. And I will have a pleasure to talk briefly on the legal basis for exclusion from public procurement for anti-competitive behavior from the European Union law perspective. Just to start with, I would need to say that exclusion grounds are among the elements which have triggered and are still triggering a lot of discussions in EU member states. And one of the exclusion grounds adopted within the EU framework on public procurement refers directly to anti-competitive behavior of contractors. A specific provision on this issue was introduced in the 2014-24 directive, and it is Article 57.4 letter D. And from the beginning, it has provoked a lot of discussion as to its understanding. I would just concentrate on some of them, some of those, let's say, discussions and controversial issues. And I will also refer to the latest, actually issued on 15th of March 2021, European Commission notice on tools to fight collusion in public procurement, and on guidance on how to apply the related exclusion ground. So first, I will talk about mandatory and discretionary grounds for exclusion, as the directive provides for two groups of exclusion grounds, that is mandatory and discretionary. In the case of mandatory exclusion grounds that are related to the most serious offenses and crimes like money laundering, terrorism, and things like that, the situation is pretty clear and means that contracting authorities are obliged to examine these exclusion grounds in every procedure and exclude a contractor to which one of them applies, except, of course, when the self-cleaning mechanism is possible and is effectively executed by the given contractor. However, from our perspective, at least two different approaches can be identified with regard to discretionary exclusion grounds. The first one assumes leaving complete freedom to the contracting authority, which manifests itself in the fact that the contracting authority decides to apply and to examine the given ground of exclusion in the contract documents and most frequently, of course, in a contract notice. In turn, in the other one, some discretion is left to the contracting authority, but only insofar as to assessing whether a potential exclusion will be consistent with the principle of proportionality. In this case, however, the contracting authority is required to examine the existence of all discretionary exclusion grounds. So from my perspective, from our perspective, it is difficult to assume that the contracting authority that is aware of collusion will conclude a public procurement contract with its participants because it has not chosen to indicate the exclusion ground in the tender documents. However, it seems that such an understanding of discretion is allowed and furthermore is common in the member states. It's a situation in Poland, however, not with the collusion, let's say, premises, but it's the situation with other discretionary grounds for exclusion. So this is one of the things that we would raise the awareness of participants of the market. The second thing is related to the meaning and the scope of Article 57 of the directive and its relation to Article 101 of the treaty that is a fundamental law in the European Union system. And if you read Article 57.4 letter D of the directive, it's clear that it differs significantly, I would even claim to say, from Article 101. However, both of these articles seem to relate to the same or similar situations. The directive limits the scope of restrictive practices specified in Article 101 because it refers only to agreements, while the treaty also mentions decision by associations of undertakings and other concerted practices. What is more, the directive refers only to practices, these agreements, aimed at distorting competition, while the treaty refers to practices which have as their object or effect the prevention, restriction, or distortion of competition. When you read the directive, one may ask the question, does it mean that the provision of the directive itself covers only the agreements that are clearly targeted or intended, aimed at distorting competition? Is it really the purpose of the Article 57? If this is the case, this would be a further and very important limitation to Article 101 of the treaty. Additionally, when reading the European Commission notice, one may take the view that agreements aimed at distorting competition are related only to behavior that occurs in the context of public procurement. Such an interpretation would exclude from the exclusion other anti-competitive behavior covered by Article 101 that take place, for example, on the private market. So it is not at all surprising that, and it was mentioned in the EC notice, that these differences have given rise to doubts as to which illegal practices are to be taken into account by the contracting authority for the purpose of applying Article 57. I'd like just to mention that, of course, European Commission has a difficult role because it's not the fault of the Commission, it's the fault of the Article 57 itself. So it's the fault, the Article 57 itself is completely unclear from our perspective. Then if we move on, then the second thing or the other thing is the concept of an economic operator used in the directive versus the concept of an undertaking using the Article 101 of the treaty. And especially if we look at the concept of an undertaking and take into account the single economic unit theory, which is well developed under this 107. The Article 101, sorry, of the treaty. The matter of the possibility, or maybe perhaps an obligation of applying the exclusion not only to a given contractor, but also to its affiliated companies within the meaning of this single economic unit doctrine, is from our perspective equally important, and it seems equally controversial. When you read the European Commission notice, Then it's just one paragraph that is dedicated to this issue, in which the European Commission stated clearly that exclusion decisions on grounds of collusion refer only to economic operator found to have concluded, and not to other economic operators in some way affiliated to that operator. So it seems that such important issue requires deeper analysis, and such clear position of the European Commission should at least be accompanied by argumentation in order to understand better the specific approach of the European Commission. Of course, if we take into account Article 101 of the treaty, then we see that under the competition law, the entity found to have colluded is assessed from the economic rather than purely legal point of view. In other words, the single economic unit theory is based on the assumption that within a group of legally distinct entities, there may be such close links resulting from ownership relations that the behavior of those entities is not autonomous, and actually they are treated as the single economic unit despite of its distinct legal basis. So the question arises here, why a similar reasoning cannot or maybe should not be adopted when dealing with the exclusion based on Article 57 of the directive. Then if we move on to more practical issues, however, of course, related to the legal ones, the question is, who is to, detect the collusion? Is it really a job for the contracting authorities? The directive clearly states that the contractor may or shall be excluded from a given tender procedure where the contracting authority has sufficiently plausible indications to conclude that it has entered into collusive agreement. It means that it is each contracting authority's responsibility to identify those sufficiently plausible indications and on their basis decide individually to exclude or not to exclude a given contractor. It seems to me that we place too much responsibilities in this respect on contracting authorities, especially if we take into account their limited resources and their limited competences. And if we add to this also the fact that such an investigation is a very time-consuming, it appears that the whole exercise looks rather unrealistic to be conducted properly within the frame of a public procurement procedure. That's why much more effort should rather be devoted to a very close cooperation between authorities responsible for competition issues on one hand and public procurement on the other. Then just two other issues that I would like to briefly mention. One is of a huge importance, is exclusion period in case of collusion. The directive clearly states that the exclusion period is of 3 years from the date of the relevant event. And from our perspective, it is crucial to define what should be considered a relevant event. In all the cases where there is no, let's say, decision of the competition authority, if there is a decision of the competition authority of a collusion or any other anti-competitive behavior, the things look simpler. But what if there is no decision? Let's say that the case is under investigation by the competition authority. What the contracting authority should do? And we said earlier that it's the contracting authority's responsibility to decide. And a lot of events could be seen as relevant in this respect. Let's say that it's a decision or the collusion itself, the fact that the two companies or more companies have colluded. Let's say that it might be also the submission of the collusive offer. Let's say that the relevant event might be considered as an award of a contract or a decision of a given contracting authority to exclude a contractor based on its collusive behavior, or any other, maybe not other, but there are a lot of events that could be taken into account. And it's crucial for contracting authorities, but also taking the perspective of the contractor that has colluded, that it's crucial to know what is the relevant event, and where is the starting point for the 3 years to elapse. Last thing, but not least, is self-cleaning mechanism provided in the directive versus leniency or fines under the competition law. What is the interplay between the two? Just one example, briefly. According to Article 57.6 of the directive, in order to self-clean, a contractor shall prove that it has paid or undertaken to pay compensation in respect of any damage caused by its collusive behavior. Okay, so the question is, would a payment of fines imposed by the competition authority be sufficient to say that the compensation was paid? From my perspective, not. But it seems that compensation is related to the harm caused to a given entity, whereas fines serve rather as a penalty paid for the harm caused to the public interest. But as far as I'm aware, the case law in at least one of the member states seems to be going in this direction, classifying fines as compensation. So there are a lot of things to be clarified, and I believe that really Article 57 is unfortunately very badly drafted. So we, the lawyers, will have a lot of things to do in the future. Thank you very much.
Thank you, Wojciech. That was very, very helpful, and there's a lot to cover. And to comment on that, Albert, as is traditional at these events, you've brought some assistance. So I hope we get two of the family for one. We look forward to your comments on these issues.
Thank you, Michael, and thanks everybody for the flexibility. Being in parental leave and during a lockdown makes things a little bit complicated, but we'll try to get through. So thanks, Wojciech, for a very interesting presentation. I think maybe just taking a bit of a bigger picture to place where all of these legal complications come in. I think one of the things that is worth highlighting is that the EU effort is a bit difficult to understand if we compare it to the US effort that we have heard about before, because the European Commission doesn't seem to be coordinating within itself. So the European Commission has the Directorate General for Competition, where it decides on the enforcement of the competition rules, particularly Article 101 of the treaty. And there's a network of enforcers at the domestic level. So say there was a case on collusion in a specific tender in Germany, then the German authority and the competition directorate of the European Commission would decide whether they should be investigated in Germany or in the EU in case the same issue is happening in other jurisdictions. But that's something that has not been of any concern to the Directorate General of Internal Market, which is the one that has issued basically the effort for the legislation that led to the directives that are in place, but also the recent guidance. So basically what Wojciech and I comment on is the sort of the procurement short-sighted approach to the exclusion of bid rigging entities that has not been coordinated with the broader enforcement efforts. And in that regard, we have so much to learn from the US that we are really a few steps behind. Now, look, concentrating on the specific rules, I think another issue worth stressing is that the solution that was created in the 2014 directives was a solution for a problem that didn't exist. So in the 2004 rules, and we keep it in the 2014 rules, it is possible to exclude any economic operator that doesn't satisfy a standard of professional integrity. So if you have reason to believe that it's falling short of its professional integrity obligations, you can just exclude a tender. And the Court of Justice had already interpreted in the Generali Providencia case, and I can put all of that in the chat later, that infringing competition rules, so basically having been sanctioned for cartel participation, was a breach of professional integrity, and therefore you could be excluded. So it was already possible to exclude infringers of competition law. But what we were trying to do in 2014 is do the even more difficult thing, which is to create a legal basis for the exclusion of those tenders that are colluding in this specific tender. So basically concurrent or emerging evidence of collusion, which is, in my view, a bit of a red herring, because it is true that the public buyer may identify some signs of collusion, but this is going to be very difficult, and probably it's going to be just for very sloppy tenders that just copy paste each other's tender or submit it from the same email address or things like that. But it's going to be the relatively low-hanging fruit. It's not for the public buyer to investigate whether there's collusion in a specific tender that is ongoing, because as Wojciech was saying, they just don't have the tools, they don't have the time or the expertise. What you can hope is that they will alert the competition authority to this doubts that they have or this indicia, and then it's going to be the specialist competition authority that is going to look into it, and maybe if need be, suspend the project, however disruptive this can be to the public interest at stake, or decide to proceed with the others, but just make decisions coordinated with the competition authority. What we have here is a problem that is being exacerbated by the Court of Justice, because in recent trend of case law interpreting exclusion rules, the Court of Justice has come to the position that the decision to exclude on any of these grounds is a discretionary authority by authority decision, so that you don't have, as a contracting authority, necessarily to rely on the decision of another entity, even if it's a specialized entity, so that you can exclude. This only makes sense from a pro-exclusion perspective. So if you want to exclude before somebody else has decided, just because you think there are enough grounds not to have to await that final decision. But it doesn't work in the sense of forcing every contracting authority to have to make a judgment call that they may not be in a position to make. So I think this case law is being problematic because it forces every contracting authority to make a full administrative decision on whether to exclude or not, simply relying on a previous decision, say, by the French competition authority that had excluded. And this is very problematic. It's also problematic because it conflates two issues, which is one is the ground for exclusion. The other one is the compliance they mentioned, for example, of self-cleaning. So it could be that self-cleaning has to be assessed by every contracting authority on every occasion, simply because it's a dynamic process. So a contracting authority may not have been convinced last month that an entity had done enough to clean themselves, but they have kept on going, implemented more measures. Maybe they have cleaned themselves enough for another contracting authority to decide not to exclude them this month. But that doesn't change the original ground for exclusion. So we have a lot of legal complexity, and as Wojciech is saying, it's basically a lawyer's feast. I'm sure lots of people are charging lots of fees for these things. We were trying to get some clarity with this guidance that came recently from the European Commission, but it's really not useful. It's not very useful because it concentrates on this strange, difficult situation of excluding somebody that is right now colluding for this specific tender, but it gives practical information that is mainly based on the previous OECD guidelines on how to spot and deter bid rigging in public procurement, which take the longer view. So they promote analysis that is cross-tender and across time. So you can start seeing whether there's, for example, a bid cover carousel or things like that. This is not something you can observe on the basis of a single tender. So most of the practical information in the notice is pretty much of no use to a contracting authority that suspects that there is collusion on this specific case at this specific time. And the question has been posed by Wojciech is, do we really want the public buyers to be doing this job? Or do we want to simply say that there is this issue and get competition authority, can you help me with this? And I think this is something that is not well sorted out in the European Union. So fundamentally, we don't have the regulatory infrastructure that would facilitate this collaboration and joined up approach that is emerging in the US. And that's very much a cause for concern in my view. If we go to the next slide, Chris, please, in the interest of time. Then let's try to put this in a broader picture. So the EU is trying to do this complex thing in a discoordinated way, and it's not really working. But this specific European approach basically reaches a big problem when we consider cross-border situations. And maybe the cross-border situation that we would have traditionally considered is, can we have cross-debarment between the US and the EU? And this is something that was somehow mooted under TTIP. And maybe this is a way forward in the future. But now it's a much more relevant issue because can we have UK-EU cross-debarment of bid riggers? And I think this is going to create lots of complication, particularly if the UK decides to take a different path. And we will hear about this from the next two panelists. But basically, the European rules are just European-centric. They don't facilitate taking into account, for example, sanctions for antitrust violations in the US when you're assessing whether a tender is what we wouldn't call it responsive, but responsive under the rules. And it's just mainly about what's happening within one member state. It's even difficult to identify whether you can cross the bar across jurisdictions in the EU. It's not obvious, in particular under the case law of the Court of Justice. So that is one big problem, that our rules are also not scalable and don't facilitate international collaboration. And I'm sure that Dan is going to be disappointed to hear this. But the other thing is that we want to theoretically achieve this sort of perfect competition. So we want to prevent even simultaneous or contemporaneous bid rigging in one specific tender. That's why we have these very complicated rules. And this would maybe indicate that we want to achieve maximum competition for our tenders. But then to pick up a few of the points that Michael had raised in the introduction, that's not really the model of international competition for procurement that the EU is actually developing. So if we look at what the EU has been doing in terms of trying to force maximum reciprocity in trade access to procurement markets through the 2012 and 2016 repeated proposals for this international procurement instrument, but also more recently on this proposed regulation on foreign subsidies affecting the internal market, on which, by the way, there was one excellent Chris and Michael show a few months back. So please follow the links on the slides for that. What we see is that actually the European Union is more and more interested in curating competition for their tenders. So they don't want foreign subsidized participants that can come and be very competitive in price. They don't want foreign participants that are coming from jurisdictions that are seen not to enforce the same social and environmental protections. They don't want tenders from jurisdictions to which the EU tenders cannot necessarily access. But what that means is that there is a very increasing approach to restricting international competition for contracts. And as Bill was telling us before, what that means is we are making cartelists within the EU a massive favor by just excluding foreign threats to the way that they are colluding. And in particular, we think about the big industries, the ones that carry the big tickets, they are quite oligopolistic in structure anyway. Even the new industries that need to emerge, so everything that will have to do with green technology, with sustainability, are going to be quite oligopolistic because we need big players if we are to compete in the worldwide market. So basically what we're creating is a system where collusion is almost unavoidable by the structural design that we are making of our procurement markets. And at the same time, collusion is very difficult to protect against because the legal rules are really not doing a very good job. So quite frankly, it's a bit of a wrong direction of travel. And I wish that the Commission would think and change course in some of the issues, particularly just abandoning the protectionism that is emerging from the international procurement instrument and the foreign subsidies regulation, in my view. The other issue, just to make a final point, is that all of these protective or protectionist efforts actually undermine the possibility for multilateral or global collaboration, because it's just the EU having decided that multilateral fora doesn't work anymore. And what they want to do is take unilateral action to address all of these problems. There's going to be issues of extraterritoriality. There's going to be a few jurisdictions that will feel we have thread on their toes. And I don't think we're going to be creating partnerships going forward. So frankly, we're not making any friends with all of this. And I think that the key point is we are not understanding that if you actually want competition for tenders, what you have to worry about is precisely the issue of data. So what we need now is analysis that goes beyond the specific tender. What we need to look at is a better understanding of the markets, market dynamics, and being able to spot or even anticipate some issues. There's interesting work on that being done in jurisdictions like Ukraine, where there's, or Korea famously for a very length of time, because they have a wealth of data. So I think actually we want to be serious about all these things. What we need to do is create a data infrastructure that supports the development of analytics and the deployment of that artificial intelligence in this area. But this is probably a matter for another day. So thank you for your 10 minutes, and I'm happy to take questions and answers in a few minutes. Thanks very much.
Great. Thank you very much indeed, Albert. That is fantastic. And now we move to the UK. It's a good picture, Chris, you've got there. That reminds us of the days when we used to take law enforcement seriously and lock people up in that little building on the left for certain things, things like messing around with public contracts, like the Navy board contracts and things like that. I think Samuel Pepys spent a little while there, didn't he, for getting his hand caught in the till or something. Anyway, without more ado, to bring things forward to today, Juliet Enser is going to give us the perspective from the Competition and Markets Authority. Juliet, please take it away.
Thank you, Michael, and thank you more generally. It's great to have been invited to this event and explore how the different jurisdictions are tackling the issue of bidder collusion, particularly because I've been struck by the commonality of the issues that we're facing and the potential solutions, underlining the importance of learning from each other. So with this in mind, I'm going to spend the next few minutes talking about the CMA's approach to collusion in public procurement. Unfortunately, I do only have a few minutes, and it's a topic that I feel quite passionate about. So please do excuse me if I end up speeding up. But I gather there's going to be a recording available, perhaps. So if I speed up so much that I become incomprehensible, you can watch me again on slow motion. I think it's obvious from this slide why I feel passionately about bid rigging and public procurement. If you look at the sums being spent through public procurement and the potential harm from collusion, if it is present, becomes evident. And it's harm that's felt throughout society, by taxpayers, and indeed by all of us who use public infrastructure and services and who are potentially being denied the benefits of competition. And as I think other speakers have flagged, it's increasingly important as we emerge from the pandemic and as public spending on areas like infrastructure increases, the role of public procurement in delivering high quality and good value services becomes even more important. So what is the CMA's role in relation to bid rigging and other forms in collusion? So we are, as you're probably aware, the primary agency that enforces competition or antitrust rules in the UK. In a post-Brexit world, that includes taking responsibility for some of the larger and more international cases that might previously have been dealt with by the European Commission under its exclusive jurisdiction. So the framework which we're enforcing, governing collusion in procurement, is broadly consistent with the approaches adopted under the antitrust or competition rules in both the US and the EU, and indeed beyond. So while there are some differences in our legal regimes, I think the overall approach is pretty similar. And I think Michael already highlighted, bid rigging is considered as one of the most serious forms of anti-competitive behaviour under our regime, which can attract high corporate fines. And as in the US, individuals can also be held accountable for their part in the wrongdoing. And I'll say more about that and the mechanisms that apply there in a minute. So given the CMA's role as the primary competition enforcement agency, we clearly have a key role to play in preventing bid rigging in public procurement. But it's also true to say that other bodies, such as the public procurement themselves, have a role to play too. So our strategy in terms of tackling bid rigging follows a kind of complementary approach. So firstly, and most importantly, as I said, we take enforcement action, which itself then acts as a deterrent to further wrongdoing. But we also work to support public procurers through training on the risks of bid rigging, including how to spot and report cartels. We also, and Michael averted to this, take a sort of a broader interest in improving procurement design and the procurement framework more generally, with a view to promoting healthy competition, and are working with government to ensure that new public procurement rules work effectively. Can I have my next slide, please? So, as you would expect, and I said, most of our focus is on enforcement action, including imposing fines on corporates and also holding implicated individuals to account. Bid rigging and other forms of collusion in public procurement, because of their serious nature, attract penalties at the higher end of the scale. That form of cartel is also increasingly attracting use of our directed disqualification powers. It's probably worth me explaining this power, which I think is relatively specific to the UK, but essentially the regime works such that directors of companies that infringe the competition rules can be disqualified from acting as directors in any company for the period of the disqualification. And we now routinely consider, in all cases where competition law has been broken, whether to seek the disqualification of directors of the companies concerned. We also have criminal enforcement powers in relation to individuals involved in a cartel. We'll consider if cases are suitable for potential criminal enforcement. So to give you a flavour of our work, highlight a couple of examples of cases which involve bid rigging in the construction sector and including public sector products. So most recently in 2019, we fined 5 companies in the office fit out sector, a total of £7 million, and also secured the disqualification of 6 company directors. Previously, we've taken action against water tank suppliers used for water storage for sprinkler systems in large buildings such as schools. Indeed, if you look at the construction construction sector as a whole, which is obviously a key sector for public procurement, since 2015, we've issued fines of £67 million across 5 separate cartel cases covering a range of products and services. Alongside these fines, 11 company directors have been disqualified, and there's also been 2 criminal convictions. So in addition to enforcement action taken by the CMA, businesses found to have infringed the competition rules in the UK, as with other regimes, risk further consequences, including damages, claims, and reputational harm. There is also the potential for competition enforcement to lead to voluntary redress, which has obviously the advantage that the government is compensated without the need to launch court proceedings. And that's an approach that's been used in the pharmaceutical sector to secure compensation for our National Health Service. So along with enforcement, we also work very actively to increase the risk of detection of cartels. And that includes our work with public procurers, which I will come on to shortly. In terms of how we learn about cartels, the CMA, like most competition agencies, operates a leniency program under which companies involved in legal activity can self-report. So provided the conditions for leniency are met, the first company to bring a cartel to the CMA's attention will attract relief from fines, and also for their directors and employees, relief from direct disqualification and criminal sanctions. And I think it's fair to say that we anticipate that this programme will, for companies operating in the UK, become even more important now that the UK has left the EU. And as I mentioned before, the CMA will be able to investigate cases, particularly those with an international dimension that might previously have fallen to the European Commission. So that said, and I think it's quite important to underline this, while we do have incentives to report cartel behaviour through our leniency policy, we're not dependent on that. And indeed, only about half of our cases result from leniency applications, with the rest being what we describe as intelligence-led. While I'm on the subject of detention, I should, of course, mention our work on screening tools, which is obviously an area of continuing interest. We are lucky enough to have a great data unit in-house, and we're continuing to look at how screening tools can be used both in the context of bid rigging and public procurement, including working with other agencies. And you'll be not surprised to hear we do cooperate with other agencies across our work. So, for example, we have a memorandum of understanding with the SFO, the UK's bribery prosecution agency, which sets out how we will cooperate and support each other in investigations of mutual interests, and signals our commitment to work together to tackle cartel cases, particularly those which cross the line between bid rigging and bribery and corruption. And we have close contacts with the SFO and regular discussions between our teams, including our respective intelligence functions. So moving on, I wanted to talk a bit about our work with public procurers, which we see as increasing the risks for cartelists and therefore part of our broader enforcement programme. And we've been doing quite a lot of work in this area recently. So last month, we rolled out a new e-learning training module for public procurements on how to reduce the risk of bid rigging, spotting red flags and reporting suspicions. And this supports existing CMA advice and is part of a wider education programme to raise awareness of cartel behaviour, which sits on our website. We're also providing training in person, or probably not in person at the moment, but more virtually, to procurement teams across central and local government to increase awareness of the risk of bid rigging. So we work with the government commercial services function, which includes officials working in commercial roles on every central government department, to ensure that key information about the risks of bid rigging is brought to the attention of procurement teams. So together, these initiatives are intended to help public procurers run public procurement processes in a way to minimise the risk of bid rigging, but also to encourage contractors to comply with the law. if bid rigging does occur, then greater awareness of red flags and how to report suspicions to CMA will lead to increased reporting by public procurement officials and increasing risk of detection. We also worked with public procurers and policymakers on designing public procurement processes in a way that promotes competition and healthy market. So I think it's no secret that having a limited supply base can increase the likelihood of bid rigging. So we see promoting healthy competitive markets as helping to address this risk. And of course, there are wider benefits to doing so. And there's more about the work that we do in this area in our response to the Green Paper that Michael referred to in his opening remarks. So I've said a lot here about our enforcement work and our training work with public procurers. I just wanted to finish by saying that we also recognise that most businesses want to comply with the law, and indeed much of our outreach work has a focus on helping them to do so. That said, you'll be less than surprised to learn that we're prepared to come down hard on those businesses that don't.
Thank you very much, Juliet. Right. So our next, where are we? You've got your next slide? There we are, cheating. There we are. Muted. To comment on the situation in the UK developing on the back of her recent article, Professor Alison Jones. Alison, would you like to take it away?
Thank you very much, Michael, and to you and Chris for inviting me to participate in this this conference. So I think previous speakers have already drawn attention to the susceptibility of public procurement processes to distortion by collusion, to the significant harm that bid rigging practices in public procurement contexts can cause, not only to the economy, but to the welfare of citizens more generally. That the vast sums of money that's spent on public procurement each year, and the special relevance of public procurement today at a time when governments across the world are spending vast sums of money in fighting the pandemic, and consequently also have considerable pressure on the public purse. So all of this highlights the crucial importance of jurisdictions having in place mechanisms for reducing opportunities for collusion to distort public procurement processes, to root it out when it does occur, and to punish it and deter it. So Juliet's very kindly just run us through the UK system, and we can see that at first glance, we have a pretty good system in place in the UK. There are comprehensive public procurement laws. Michael's already referred to some problems with those. We've got gold standard bribery laws and competition laws with active and internationally respected enforcement agencies at the helm of them. So the common view is that we don't really need to be too worried about this problem, perhaps, and especially as the UK is a relatively clean economy. But I think that nonetheless, there are reasons to be concerned that collusion could be operating under the waterline and undetected in the UK. And this could be a result of some sort of weaknesses in the systems, especially in the application of the public procurement laws and in enforcement of competition laws, and perhaps as a result of insufficient policy coordination. And perhaps there is a need for greater cooperation here between competition, anti-corruption and public procurement agencies. So I think this more could be done in the UK to bolster and reinforce the current regime, which has very good foundations, and especially through recognising the interconnected nature of the laws in this area and the need for the policies to be implemented in a more integrated and joined up manner. So perhaps we could have the next slide. So I think we've already referred to the fact that the government is already having a post-Brexit review of the public procurement regime. There's debate and consideration of how the competition law regime should develop post-Brexit as well. So there is opportunity for these issues to be thought about in the next months to come. So I think, and I think Juliet has already discussed a lot of these points. The CMA is obviously already thinking hard about these things, but I think what we really need to do to try and make sure that collusion is rooted out is to think about both prevention and deterrence, which is a function of both the risk, the probability of detection, and the likely sanctions that are going to be imposed. So I think it's imperative that more needs to be done here to try and safeguard against the collusion risk during the procurement processes. And it's very heartening to hear that in the last month, the CMA has got an e-module going for procurers. I would suggest that this ought to be mandatory training for procurers, and also in-person training when it's possible will help to build closer links between the CMA and procurers. And this will help procurers to understand the benefits of pro-competitive design, how to put in place tenders to encourage the greatest number of bids, how they can use certificates of independent bidding and other factors to make collusion more difficult, and to understand the tensions that can exist with some procurement tools, which might be designed to encourage transparency, but might nonetheless facilitate collusion. But secondly, I think the need to deter is important, and I think that Juliet's referred to competition enforcement under the Competition Act, but I think when you look down at the cases that have occurred, does not seem to be an area where that's, to date at least, that enforcement has been prioritized. And I think given the huge cost of public procurement and scale of public procurement, this could be an area where the CMA might want to focus its resources. Secondly, I mean, Juliet's already talked about detection techniques, but many competition agencies do now rely quite heavily on leniency programs to find out about cartel infringements. But obviously, they are only going to be successful and work if there is a risk that if firms do not self-report, that the conduct will be uncovered. So I think bolstering tools for detecting breaches in other ways are going to be very important. And we've talked a little bit about screens and data analysis already and how important these are. And as I understand it, relatively simple and easy to use in the public procurement context and fairly reliable. And I know that the CMA did have a data analysis tool, which it withdrew, but it's great to hear that they've got a data unit now thinking about these issues again. One other thing that they could perhaps be thought about in this area, if they are working more closely with procurers, is to really encourage procurers to be vigilant for bid rigging and report it to the CMA when they find out about it. And perhaps there could be some financial incentives, extension of whistleblowing tiers that exist to try and encourage this. The third prong, I think, of this would be to think about the sanctions. And I think the current system is heavily reliant on corporate fines under the Civil Competition Act 1998 cartel offence. And I think there is reason to be concerned that corporate sanctions alone may not provide a sufficient deterrent to offending, because they may not be able to be sufficient to offset the benefit of colluding. So I think it's really important that the CMA and thinks about other sanctions both for corporations and for individuals. So in relation to corporations, we've already had quite a bit of discussion about debarment for firms involved in cartel offences from procurement processes. And I think there's a lot of work that would need to be done in the UK to make that a more effective system. So one possibility could be to make mandatory debarment for cartel offences, and to sort of bolster the system through having a more central system, a central register of companies that are debarred, etc. Another advantage would be if there was routine bringing of damages actions by the government in relation to infringements, bid rigging, which has affected public procurement processes. But then in addition to focusing extra sanctions on companies, it's also imperative, I think, that there are sanctions for individuals and the individuals responsible for the cartel activity. Juliet's already mentioned that the CMA does have power to seek disqualification of directors of companies involved in cartel offences. This is under the civil offence. They can do this. They hadn't really used this power very much until 2016, but now they are routinely using it. I think it's been used 18 times since then. So that's raises the stake for individuals as well. But I think what we didn't hear much about is that we do have in the UK a criminal cartel offence, which can apply to bid rigging. And the criminal cartel offence has not been a great success. I think it's only 5 individuals since 2003 who have been found guilty of this offence. They all pleaded guilty, in fact. The former chairman of this CMA, Andrew Tari, did ask the government to be relinquished of its right to obligation to enforce the criminal cartel offence for a number of reasons. But I think we're at a bit of a crossroads here, and we need to decide whether to reinvigorate the criminal cartel offence and abandon it, and think about, if we do abandon it, whether we need some other sanctions for individuals to bolster the deterrent effect of the rules. Anyway, I better stop there. I think I've had my 10 minutes, but I'm happy to answer any questions.
Thank you, Professor Jones. Much appreciated for that excellent overview. Although I'm going to tell you that I definitely woke up a little bit more when I heard the words mandatory debarment, if anybody's done any reading of my scholarship. Not a fan. But we can discuss that at a future date. We are pretty much out of time. So now I'm going to leave it to one final question, for which I will give both Dan and Juliet 30 seconds each to respond. So best of luck with that challenge. We're going to kind of combine everything. What is the path forward for governments to continue to cooperate given the differing standards and different regimes? And we did also get a question too about whether it's possible to set aside a contract that's been tainted by collusion. So Dan, maybe we'll start with you again. Given being mindful of the time, what are your thoughts? Can you solve that and provide us the answer to world peace in that time period? Thank you.
Perhaps I can also provide the meaning of life in my remaining 27 seconds. I think the path forward is building on relationships. Part of my presentation was describing how we are trying to build the relationships between complementary enforcement authorities within the United States, breaking down silos or stovepipes, And I think that work can be transferred and built upon internationally. The United States and the United Kingdom, for example, have a long and the special relationship, and that includes in the cartel enforcement space. That includes a lot of efforts at bilateral, multilateral cooperation. And I think that recognizing the different legal standards, as you point out, is an important factor of that. And while I don't have any magical answers, I think it's really sort of building on what we know has worked. I'd be curious to hear from Juliet if she has different views.
Not at all. I mean, I think as Daniel said, we've a long experience of cooperation between our two agencies, and always looking to see how that can work better. And as you say, we have different legal standards, slightly different approaches. But as I said during my presentation, I'm actually struck, in this area in particular, I think we have an awful lot in common.
Okay, well, you didn't get the meaning of life, Dan, but still grateful for that assessment. Thank you to all of our fantastic speakers for addressing these really critical and important issues. We really greatly appreciate your time. And again, thank you to my colleague, Chris Eukins, for organizing this event. I'm putting a lot of time into it. Thank you to Michael and King's College London also for their continued partnership in these really important series of programs and webinars. For those of you who have not been been glued to the chat function, Chris has routinely provided links to his blog, Public Procurement International, where a lot of the resources referenced in the slides and during these discussions are going to be. And at some point by the end of the day, I will have a recording of this up on the GW Law Government Procurement Law Program's YouTube channel. So again, thank you everybody for your time and your contributions, and have a wonderful day. Take care.